Sir, Elangovan sir, can you start the session, sir?
Please, sir, carry on, sir.
Okay, thank you.
Thanks, sir. Thanks.
Very good morning, dear leaders. It's been a pleasure to welcome you all for this 50th INVITI Industrial Empowerment session. And thank you all for joining on time. On behalf of INVITI, on behalf of you all, we welcome our Dr. Elangovan sir for this meet, and we thank him for spending his very valuable time on his busy schedule. We will start our session as per have been planned. First, INVITI. INVITI is being invent, innovate, and inspire. With this theme, it has been founded by alumnus of CEG College of Engineering, RLA, and IIT to inspire the world by technological inventions. It has been founded on 2020. INVITI verticals. INVITI is having the four verticals of research and development wing, audit and inspection wing, corporate training wing, and health and wellness wing. These are the four wings of INVITI verticals. In research and development wings, these are the different research projects which is being done by INVITI. 2019, because they have been came out with the development of augmented reality, a kind of training model. Then in the time of COVID pandemic time, we have been came out with the INVITI COVID Smart CCTV, which can able to detect the people's whom they have been going to wear a mask, they have been not going to wear a mask, it can able to detect. In 2021, a drone surveillance in the confined space, it has been very successful. It has been inducted in some of the industries, and not only a projects, not only a kind of technological inventions, the research and development wings of INVITI, they have been came up with some of the new topics which has been much suitable for this era, which is known as mind re-engineering. In 2021, they have been came up with a mind re-engineering concept. On 2022. Ergo yogic practice. Ergo yogic practice is nothing but a combination of economics and yogic practice to ensure that a kind of a chronic disorders or the chronic pains have been addressed, and then we have been working on learning management systems. It's a form of LMS. Nowadays, we all know that after this COVID, LMS has been a most important part of it. Our research and development wing, they have been started working on it. Next, a corporate training. INVITI, we are very much proud to say that INVITI is the first Indian firm to have a learning solution in all the three verticals. The three verticals, which has been started from conventional learning, a kind of de-learning, and also action learning, digital learning, and also action learning. We have been much happy about this. These are some of the training domains based on safety, quality, technology, and managerial skills. INVITI has been proud to say that 16 subject matter experts have been aligned with our INVITI. INVITI on 2021, August 15 is one of the most important milestones for INVITI and also for all to ensure that the CPR, a skill for all to save all. With this thing, more than 43,000 people have been lively, they have been witnessed the CPR. And also we have been proud to say that INVITI has been taking steps. INVITI has been taking steps with other stakeholders to ensure that the CPR basic life supports is being a part of the industry itself. It's a part of a kind of educational institution itself. I've been requesting the participants. I've been requesting the participants to put on mute. Thank you. Next, our audit and inspection wing. Audit and inspection wing has been having from ISO certifications, NABM, NABH, and IS 14489 to the legal requirement. These are some of the important functions of audit and inspection wing. Last but not the least, about the health and wellness wing. The health and wellness wing is been ensuring that the chronic pains or the chronic disorders of the employees have been addressed well. So the first thing, our health and wellness wing, they have been concentrating on pro-economic practice, which has been incorporated in occupational health centers itself. Next, which has been establishing a yogic pro, a kind of occupational healthcare centers, and establishing a counseling centers in the institute. Because nowadays, this a kind of mental hygiene is being more important. We have been talking about health hygiene. Yes, it's a day that we have to talk about the mental hygiene to ensure that the kind of health and wellness wing of INVIT is been ensuring that a kind of establishment of counseling centers in the industries have been done. And in a kind of INVIT industrial empowerment session. Yes, INVIT industrial empowerment session have been started on 2021 May 1st to ensure that a knowledge transformation, knowledge sharing has been done with all the industry empowerment to ensure that our industry people have been empowered in the coming technological things. So we have been started with all of your supports on May 1st, 2021. As of now, 37 experts from national and international have been shared the knowledge in different domains. It's like a 360-degree holistic education. We can able to proudly say, with your support, constant support, this is the 50th session, and we have been pleased and we have been humbled and we have been showing our gratitude to our Dr.R.K. Elangovan sir, who have been accepted our invitation and to take part in this 50th session. In this moment, we like to thank our participants, most most importantly, person from KTV, Balu sir, and Manavalan sir, and also Kim Sasiva sir from Titan, who have been part of our entire 50th sessions. So thank you all. Now it's time to welcome you all and also our chief guest, Dr. Elangovan sir. We have been going to see a kind of unique welcoming by a kind of yogic practice. We can able to witness a kind of unique, our traditional welcoming in a short way. Thank you. Stay tuned. Thank you all.
Sir, audio.
Yes, sir. Thank you. Okay, thank you for it. A kind of new kind of traditional welcoming you all for this session. To have a introduction about our speaker today, Dr. R.K. Elangovan sir, I welcome Mr. Murali Krishna sir for this forum.
Good morning, everyone. I hope I'm audible, and it's a great honor to be introducing Dr. R.K. Elangovan. Welcome, sir. It's been a privilege to introduce you, sir. Dr. R.K. Elangovan has finished his bachelor's in engineering, mechanical engineering from the College of Engineering, Indiana University. And he did his M.Tech Machine Design in Indian Institute of Technology, Madras, and the PGDBA from Annamalai University. And he has PhD in Industrial Safety and Education from Alayappa University. And he did his MSc Environmental Sciences from Bharatiyar University and higher doctoral program from Dehradun, India, UPES Dehradun, India. And he has many scholarly reputation for his name. And he has secured some of the prestigious award in this field. He secured first class distinction in Bachelor of Engineering degree course Anna University and awarded Pannattur Subramaniam Silver Medal for proficiency in mechanical engineering during 1988-89 and selected and included as an industrial safety expert in the 2010 edition of Marque's Who's Who in the World, distinguishing as one of the world's foremost achievers in the field. His work experience varies in different fields, and presently he is working as a Director General in Directorate General Factory Advice Service and Labour Institutes, Mumbai. Previously, he was working in the same institute as Deputy Director General, and he has been the Director in Central Labour Institute, Mumbai, and Regional Labour Institute, Chennai. And he has been the factory inspector in the Department of Inspectorate of Factories, Government of Tamil Nadu for 16 years before achieving his milestones. He has some 23 positions in key projects where it came to designing and executing safety precautions for government and private sectors.
And thank you, sir. And thank you, Murali Krishna sir, for the introduction of a renowned Dr. R.K. Elangovan sir. R.K. Elangovan sir, it's a pleasure to have you here. And thanks for accepting our request once again. The virtual flows is yours. Thank you, sir, once again.
Yeah. Good morning, organizers and participants. It's a pleasure to be in this platform on a Sunday. We are having around 100 participants from the entire country. That shows the keen interest shown by the delegates who are specialized in the field of occupational safety and health. I believe my audio is fine. Organizers in VT may give their comment. So I will straight away go to the presentation. So whether my screen is visible?
Yes, sir.
Yes, sir.
Fine. So I will be taking another 1 hour. I think up to Prabhakar told me that maybe up to 12:15 we can take the session and we can take questions later. But I believe that if you have any serious question to be asked, even during the program, You can ask it, you can interrupt it, and you can raise the question for the better understanding and appreciation of the subject. Today, we are going to talk on the Occupational Safety and Working Conditions Code 2020, accepted by the Honorable President of India, and the Act which has subsumed 13 legislations, including Factories Act, Mines Act, Building and Other Construction Workers Act, Dock Workers Act, Plantation Labor Act, and other laws. To talk about DGFATLI, it's the organization under the Ministry of Labour and Employment, Government of India, and we are mandated to work on occupational safety and health in workplaces. Then we have institutes under us. One is we have one Central Labour Institute in Mumbai, Regional Labour Institutes at Chennai, Faridabad, Kanpur, Kolkata, and Shillong. We are building in the construction phase. The current year, we expect it to be operational. We are the apex body in the field of occupational health under the Ministry of Labour and Employment. So before going to the code, we need to also understand what is the framework of OSH in the country. DGFATLI and our institutes play a pivotal role in driving OSH at workplaces. And international scenario with the ILO, that has come out with a lot of conventions. And many conventions are safety and health. And Government of India also ratified the convention. The process of processing further on many conventions. In the year 2009, February 20th, the Government of India declared the national policy on sheep at workplaces. Then in the year 2019, we have published the National OSH Profile, National Occupational Safety and Profile, with the technical support of ILO. It has been already approved by the Honorable Minister and it has already published. Coming to the regulatory framework, as I mentioned, all these the top 5 legislations are having the original jurisdiction, and the OSH Code 2020 will be subsuming this legislation once it is started implementing. So, to give a brief background, the 44 labor laws are made into 4 codes, and these 4 codes: occupational safety and health, industrial relations, social security, and wages. All these 4 codes subsumes almost 29 legislations, labor laws, and repeats around 12 labor laws. So this is please, somebody is raising the hand.
I think mistakenly they would have been raised, sir.
What is it?
By mistakenly they would have been raised.
Okay. Okay. So if you look at the different codes, how many acts it has been subsumed, how many sections, and how many sections are proposed, I would touch upon the Occupational Safety and Working Conditions Code. And this code has subsumed 13 legislation. Of course, the current laws, we have 622 sections. The new code will bring out 143 sections. I would also like to mention on this code. This code was accepted by the Honorable President in the month of September 2020 and has been very published in the public. Very important point in the codification, why the labor laws have come into codification. Talks about one registration, one license, one return, and minimum forms. The forms are by and large electronic e-forms, e-documentation, uniformity in definition, and multiple committees are reduced to few, web-based, randomized, and jurisdiction-free inspection, introduction of technology, particularly electronic registration and licensing, reduction in the compliance cost, and reduction in litigation. These are the advantages of codification. As I told you, these 13 legislations, it almost covers factories, mines, dock, construction workers, plantation, motor transport, and beauty and cigar. So 7 sectors, 3 types of workers: contract labor, interstate migrant worker, and working journalists. So it will be taken care. And if you see the code, as the code is concerned, it talks about occupational safety in different sectors, ventilation, drinking water, welfare provisions, interstate migrant workers, and including licensing procedures. I'll be trying to cover the complete system subjected to time constraint. Now you can see here the Factories Act, Mines Act, Dock Workers Act, DOCW Act, Plantation Labor Act are subsumed by this legislation, the code. And if you look, we have about 14 chapters and 143 sections and 3 schedules are there in this particular code. And you will find the code talks about appropriate government. Definition used. Basically, it means the central government, the state government, as the case may be. There are 2 governments, certain structure. The powers are given to central government, some are given to state government, some are given to both the governments. So, wherever the appropriate government word is used, it connotes the corresponding state or central government or both. Then the code introduces the term employee and worker. There is a new introduction, I would say. And you can see any person employed on wages in an establishment to do any skill, semi-skill, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical, whether the terms of employment is expressly stated or implied, whatever the case may be. But here what you see is, it is a person and employment on wages, and terms of employment need not be always expressed, it can be even implied. Then we come to the definition of worker. Same definition, any person employed in an establishment. It includes every category. But only thing is, the person working in Air Force, Army, or Navy, they can't be a worker. Police department officers or employee of a prison cannot be a worker. And anybody employed in a managerial or administrative capacity cannot be a worker. And any supervisor who is working in supervisory capacity, drawing more than 18,000 rupees per month, or an amount as may be specified, notified by the central government, cannot be a worker. So to compare, except the supervisor drawing 18,000 and above, persons working in managerial or administrative capacity, all will be workers. Then the law provides for employer. Basically, the employer is the, in case of, you can see, he is also a person. And of course, if the central or state government, authority specified by the head of such department. If not specified, then the local authority, CEO, chief executive of the authority. And in case of a factory, the occupier of the factory is the employer. In case of a mine, the owner of the mine, agent or manager, referred to in section 67 is the employer. In relation to any other establishment, the person who or the authority was ultimate control over the affairs of the establishment, and where said affairs are entrusted to a manager or managing director or such manager or managing director, the contractor and legal representative of the the employee. They are the employee. And the establishment, in fact, you can see the definition. The establishment is a place where any industry, trade, business, manufacturing, or occupation is carried. So it's in line with the constitutional provisions of occupational safety and health. Every industry, trade, business, manufacturing, or occupation will be covered under this code. It's by and large equivalent to safety and health at work. That's the overall perspective. It also says about motor transport and taking inspector establishment, audio video production, and your VOW lactation. And in those categories, even 10 or more workers are employed. It's an establishment. Whereas in case of a factory, if 10 or more workers is the establishment, but application of the law, there's a different, the factory definition is coming up. That means factories employing 10 or more will be an establishment, but the provisions of factory will be applicable to only certain category of industry. A mine or a port or vicinity of port, irrespective of the number of workers, will be an establishment. Then we have the definition of building or other construction work. Here, it is the definition, you can say, exactly replicating what is there in the current BOCW Act 1986. Always when we talk about BOCW, building or other construction work, we mean construction, alteration, repair, maintenance, and demolition. So everything is covered. And the building worker is also defined as a person employed to do any highly skilled, semi-skilled, or unskilled manual technical work. Same category. And we have a cargo, basically is something carried in a ship or a vessel or a vehicle. And the very important point is the inspector will be redesignated as inspector cum facility, totally having the different perspective on the inspection system. He will become inspector cum facility. As you see the factory definition, where if 20 or more workers are employed or were working on in any way in the preceding term. In fact, we always say the current definition is 10 workers with the power in the manufacturing process, whereas now the factory section 2WI1 will be that if 10 people, if 20 or more with power is employed in the manufacturing process, with the aid of power, it's a factory, or 40 or more workers are working in the manufacturing process on any one day in the preceding 12 months, without the aid of power, then it's a factory. And you see, hazardous substance has been defined under this code. Any substance or such quantity of a substance which may by reason of its chemical or physiochemical properties or handling is liable to cause physical or health hazard to human beings or may cause harm to other living creatures. And the code also defines section 2 that industrial premises, any place where an industry, trade, business, occupation, or manufacturing is being carried there. Now, if you look, the machinery is also defined under the code. That means any article or combination of articles assembled and also, intended to be converted any form of energy to perform work. So the code defines the term machinery also. Then comes the manufacturing process. It is the condensed version, but however, making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning up, breaking up, demolishing, or otherwise treating or adapting any article or substance. Very important is with a view to its use, sale, transport. This is a very important issue. These are the definitions currently also in the factory that pumping of oil, water, sewage, generating and transmission of power, then composition and printing. Then we have construction of the reconstruction, repair of the breaking of the ships and vessels. Shipbreaking is the manufacturing process. Preserving or storing in any item in the cold storage. Medical officer term is defined under section 42 under the code. And metro railway is also defined. Any trade, industry, commerce. And you come to the mine. Mine word is again, it has been taken from the mindset. Any excavation or any operation for the purposes of searching for or obtaining minerals has been carried on and includes all borings, boreholes, oil wells, and accessory crude conditioning plant, including pipe conveying mineral oil within the oil field. So it basically consists of two things. One is searching for a mineral, obtaining mineral. So there are two components that is covered here. All the shafts adjacent to or belonging to a mine, whether it is sunk or not, and all levels are inclined plans, the course of being driven. All open cast workings also comes under mindset. Conveyors and aerial ropeways inside the port area, mine area. The adits, levels, planes, machinery work, railways, and also protective works being carried out or adjacent to a mine, all workshop and stores situated within the presence of a mine. All power station, transformer substation, converter station, rectifier station, accumulator storage station for supplying electricity for a mine, and of course any premises for the time being used for depositing sand or any other material for use in a mine or for depositing refuse from a mine, then also it's coming under mine side. And it also talks about the premises adjacent to or belonging to a mine on which any process ancillary to the getting, dressing, and preparation. And of course, all the mines owned by government also comes under this. They define the terminology minerals. It's all substances which can be obtained from the earth by mining, digging, drilling, dredging, hydrolyzing, quarrying. And we also, the code defines that when water transport undertaking means a water transport undertaking employing motor transport workers and engage in carrying passengers or goods or both the road for hire or reward includes a private carrier. As I told you, the qualified medical practitioner is a practitioner who possesses the recognized medical qualification in class section 2(1) of the Indian Medical Council Act and also registered on an Indian Medical Register and State Medical Register. So probably it's I'll just try to give an overview. Basically, the codes provide for registering of a establishment. It is the duty of the employer to register within 60 days from the date of applicability of this code. They should make the application electronic. There is no need or no provision to talk about electronic other than electronically. And then the employer of the establishment within 30 days of the closing. So he has the reason to starting of the establishment and before closing also, within 30 days of the closure, then you should inform about the closing of the such a establishment. And the law gives the condensed version, or I would say abridged version of various duties of employer. This is related to factory, then duties of and responsibilities of owner, agent, and manager in relation to mine, coming under Mines Act. Duties of designers, manufacturers, importers, and suppliers. This is basically section 7B of the Factories Act. Architect, project engineer, and designer duties coming under USWA. We have the duties of the employees, and we also have the rights of employees. Very importantly, duty not to invalidate or misuse things. So this is the point. Somebody is talking about echo of voice. Probably I do not know. And when it comes to notice of certain accidents, if a worker is unable to return to work within 48 hours from the date and time of accident, then it becomes reportable. And of course, in case of a mine, employer, owner, or agent or manager shall do that. And in case of a factory or dock work, employer or manager. Then section 11 provides for dangerous occurrences. They are like fire, explosion, toxic release, collapse of building and machinery, and so on. So the notice has to be sent in the form as may be described. The government has prescribed the forms in these rules. Then we have notice of certain diseases, section 12, where any worker in an establishment contracts any disease as specified in the third schedule, then the employer of the establishment shall send the notice to such a person. Very important point is the notified diseases are given in third schedule. List of hazardous processes given in the first schedule. Second schedule talks of the list of matters 18 to F to be decided in terms of occupational safety standards. And this is a very important initiative where the OSH Advisory Board, Occupational Safety Advisory Board, National Board. This board is an advisory body to the central government. It can give advice on standards, rules, regulations to be defined and changed. Please mute your mic, please. Then what are the issues in implementation of the code, standards and rules, policy and program related to OSH, and then any other matter that may be referred. And it also provides for state advisory board, safety occupational safety advisory board. Same state structure is given. When we come to the section 18, it's a very important provision, the occupational safety standards. So far, whatever we consider as a rule or regulation will become the standard. Please mute your mic. Yeah. And what it says is the central government will declare standards. So that means the standards will be uniform throughout the country. Therefore, it is easy to comply, easy to have uniformity when it comes to the compliance to the standard. Section 18, the central government will frame standard, and the appropriate government, state and central government, as the case may be, they will be implementing those standards. And these standards on safety net by and large, and you can see the safety of standard factory, mine, dock work, building and construction work, and other establishments. And must be many of you might be knowing the government has already created 4 expert committees to frame standards on safety net for factories, dock work, and then building and other construction work, and fire safety. Of course, I worked on the factories and dock work. Of course, I was also coordinating on building and other construction work as well as your other fire safety standards. The code promotes the safety, research in the field of occupational safety and the government or central government may notify to conduct research, experiment, demonstration related to occupational safety. It is the duty of the institutions to do research activity. Then it provides for safety committees and safety officers, section 22. And here, the safety committee has become a uniform requirement. Currently, it is only applicable for hazardous process. Now, safety committee has to be formed in each and every factory. And this safety committee will be having equal representation of workers and employers, management representatives. And you can see, coming to the safety officer appointment, the factory wherein 500 or more workers are working, or factory carrying hazardous process when 250 workers or more, or building or other construction work wherein 250 workers or more. In case of mine, wherein 100 workers or more ordinarily employed, then they should go for a safety officer. The ceiling for the further safety of the appointment are provided in the central government rules or state rules as the case may be. And we also have section 23, in particular with respect to health, safety and working conditions rules. And this will be prescribed by the central government. As I told you, section 18 is prescribed by the central government. 23 also will be prescribed by the central government. And that will be implemented by the appropriate government. The expert committee appointed for safety standards under section 18 also take care of 23 and 24. And if you see this entire thing, welfare facility, the employer is responsible to provide and maintain an establishment with regards to adequate and suitable facilities for washing, bathing places, locker rooms, and and again places for keeping wet clothing, not worn during the working hours, and for the drying of wet clothes. Then sitting arrangement for the employees obliged to work in a standing position, canteen, and of course, in case of mines, medical examination of the employees employed in the mine, and adequate first aid boxes, cupboards, contents readily accessible during all the working hours. Then, when we come to this particular provision on working hours of work, it clearly says no worker shall be work in an establishment for more than 8 hours per day. Of course, the period of work in each day shall be so fixed that not to exceed such hours and intervals spread over everything is defined. Now we have a weekly and compensatory holiday, the same thing under the factory side. Only thing is, these provisions are now extended to all the establishments. No worker shall be allowed to work in an establishment for more than 6 days in any one week. That means you should be giving 1 day holiday. That holiday is as per the wages. And overtime, as you know, when you work for more than 8 hours, then you are eligible to overtime at the rate of double the wages. And this is the overtime provision. We have a night shift, where it talks about, how to calculate the night shifts. And there's a prohibition of overlapping of shift. Shift cannot be overlapping because at the same point there will be more than 2 workers. It will be difficult to multiple situation. So it talks about the prohibition of overlapping of shift. Then it also, section 30 talks about restriction on double employment. So it doesn't permit double employment in a factory. And of course, section 31 talks about the notice of periods of work. In terms of clearly showing how many workers are required to work in provision of this code. We should rather go into those issues before we take up a final call, because the notice of periods of work are very important. It is displayed, agreed upon by the concern. And we have annual leave wages. This is equivalent to or similar to your earned leave. Earlier it is 240 days, the eligible criteria. Now it has been reduced to 180 days. Of course, 1 day will be for every 20 days of work, remains same. Then we have a section 33 on maintenance of registers, records, and filing of returns. So the registers are returned electronically. Sometimes not possible, you can think about otherwise physical and other form. And they should be maintained. And you see, leave register, every register is clubbed in section 33. So the government, appropriate government, that means both central and state government in their sphere, appoint inspector cum facilitator for the purpose of this code, who shall exercise the powers conferred to them under this code throughout their respective jurisdiction. And you have the powers of inspector. One of the same, what you have in factory that to enter, inspect, and examine the establishment, equipment, plant, machinery, article, inquiry of accident or dangerous occurrence, or examine the crops grown in any plantation or any worker employed therein, or require the protection of any register, and so on. And supply of information to the employer and worker, production register, any register they can see. Then come to another important provision, the third-party audit and certification. This is the very important provision, and in this provision, the government proposes to give a third-party audit under the code that will cover both safety, health, and welfare. And the certification is in a randomized manner, and the entire third-party audit, there will be a scheme to be evolved to formulate a scheme to empower an expert specific quality. You may have thousands of experts, but the scheme should move towards empowering them and then making them available. As we discussed, the medical officer possessing the required qualification appointed in case of some factory, mines, plantation, motor transport undertaking, and any other establishment as may be prescribed. And we also have medical officers' duties, examination, certification of workers in a mine or a factory, as well as dangerous occupational process, to exercise medical supervision, and examination and certification of adolescents for the purpose of ascertaining his fitness of employment. These are the three duties. We come to employment of women, section 43. Women are permitted from 6 a.m. to before 6 a.m. and beyond 7 p.m. that in the night, with their consent. Their consent to be taken. And further, the other requirements with regard to safety and holiday working specified in the order. The code provides for adequate safety of employment of women in dangerous operations. So it talks about how to protect the women employees and what are the measures to be provided, safeguards that are to be placed to protect the employment of women in such operations. Then we come to the chapter 12, very important provision on penalty. This all of you must be, you can see everything for any rule, regulation, bylaw, standard, which may extend to 3 lakh rupees. So, not less than, shall not be less than 2 lakh. So you have a system not less than 2 lakh, but extend to 3 lakh for each and every offense. And of course, if the offenses continue, then we go into a process of 2,000 rupees for each day. Then for punishment for causing obstruction to the chief inspector or inspector, then he shall be punishable, which may, term of imprisonment which may extend to 3 months, or with fine which may extend to 1 lakh rupees or more. So in case of not permitting an inspector, it becomes a legal violation, and it is a punishable as well as the imprisonment clause is there. And if you are not able to maintain the register and record, they are given a separate punishment. So shall not be less than 50,000 rupees, but which may extend to 1 lakh rupees. Of course, he has been convicted of the same offense and doing the second time. Then we should think about shall not be less than 50,000 rupees, but it may exceed 2 lakh rupees. So any person who contravenes the provisions under this code, orders made under this code, then shall be liable to a penalty which shall not be less than 50,000 rupees based on the order. So this is the overriding punishment clause. And if you are doing a falsification of records, kind of forgery or manufacturing, and then it says 3 months may extend to 3 months imprisonment, all with the fine is extended to 1 lakh rupees. And of course, you have the penalty for omission to furnish plans. If you are not able to furnish the plans, then the penalty is provided, which shall not be less than 1 lakh rupees, which may extend to 2 lakh rupees. In fact, there are a few questions I will take it now itself. One is one Shishir Kanta Panda has talked about stand rules. Yes, rules have been already framed, particularly, the draft central rules have been already prepared by the government of India, placed in public domain. Then we have got the comments have been processed. Same way standard, the expert committees are in the process of making the standards on occupational safety net, and it is also under progress. And we come to another question. A research center approved the DG factory for undertaking safety studies. No, we don't approve as it is, but it's a legal provision. Once the code comes into effect, we can think about it. And of course, the staff work authority to workers, it's like a right. Basically, the right of the employee is to protect himself, not to cause injury to others, and not to inflict damage, not to disturb the PPE and safety equipment. They're all work towards. It's all broadly covering the staff worker. It is simply it's a duty not to do any interference to your work as it is. Then we have this punishment of disclosure of information. If an inspector or any person comes to have a knowledge on the manufacturing process or the technology, if he is revealing it, then he shall be punishable with imprisonment for a term which may extend to 3 months or fine which may extend to 1 lakh rupees. If you are doing an analysis and if you are wrongly showing the results of the analysis, then the penalty may extend to 6 months or fine which may extend to 50,000 rupees or more. In case of hazardous process, particularly section 80, it shall be punishable with a term which may extend to 2 years and with a fine. This is only one section in terms of hazardous processes. Under section 80, you have both penalty provision as imprisonment process, both together. And if there is a contravention of duties related to safety provisions resulting in accident, duties of the employer, employee, engineer, importer, chartered, everything comes under duty, then he shall be punishable with a imprisonment for a term which may extend to 2 years or fine which shall not be less than 5 lakh. So then we also have the failure to appoint manager in the mine. If you fail to appoint a manager, shall be punishable with imprisonment for a term which may extend to 3 months with fine which may extend to 1 lakh. In case of offences by the employees, then the penalty which may extend to 10,000 rupees. So even employee commits some offence, and penalty can go up to 10,000 rupees. Then again, prosecution of owner, agent, or manager of a mine. In fact, no prosecution can be initiated or instituted except the instance of a chief inspector, federal preparer, the district magistrate, by general or special order in writing by the CA. So whenever we want to prosecute, there needs to be a kind of written order, that's a general or special order in writing for such prosecution. Then there's a provision in case of exemption of owner, an agent or mine, occupier of a factory liability. In fact, if you come to know the occupier or manager has not done any mistake, then the liability can be shifted to other. Of course, we should go to the court, and the court should take a call on this. Then comes the offenses by companies. The code also talks about not only the individual, the companies may also be punished for causing any offense, or committing any offense, and then they should be, the company also can be held liable apart from the individuals. And you can see any offense committed by a company, and it is proved that the offense has been committed with the consent or connivance of, or it's attributable to any neglect on the part of any director, manager, company secretary, or other office of the company, such director, manager, company secretary, or officer shall be deemed to be guilty of an offense. Then coming to the limitations of the prosecutions, you can see very, you cannot take up a prosecution unless giving an opportunity to comply with the provisions of the Act within 30 days from the date of notice, giving an opportunity. And if the employer complies with such provision, then there can't be any prosecution against him. Normal period of limitation is 6 months as per the code. The section 114 talks about the compounding of offences, particularly composition is compounding. It gives, in case of a penalty, the penalty in terms of money, that is what penalty, which is a sum of 50% of the maximum penalty will be the compounding money. In case of offense, then it should be 75%. And if it is compounded, the person who has been compounded shall be discharged of the penalty or offense once he pays the compounding money. If he doesn't pay the money, then he shall be liable to pay a penalty equal to 20% of the maximum penalty or fine provided for the penalty or the offense as the case may be, in addition to the penalty of or fine. This very important point is the compounding money will be deposited, credited to the fund established at section 15 of the code for the purpose of unorganized workers. And of course, there are two cases where you can't compound, where the same offense has been earlier compounded, or for the same offense or the penalty it was earlier convicted. Then comes the delegation of powers. The central government may, by notification, direct that any power exercised under this code be exercisable also by the state government. And this is owner's estate. This is the provision of the Factories Act. It is the responsibility of the person accused to prove the person's age. There is no need for the inspector to prove on age. But however, the court also adheres to various procedures in ascertaining the age. Then we come, we have owners of proving limits of what is practical. It's also very important provision where it talks about you cannot ask an employer to comply with all the requirements which may not be practicable. So, because this is in line with the UK legal jurisprudence, talking in terms of as far as reasonably practical. Whatever you are trying to say or implement or to be followed, they must be reasonably practicable, and only they can satisfy the requirement. This is the power of the appropriate government. I already told you the appropriate government is the state government or central government, as the case may be, to, in case of an accident in an establishment, or it causes a damage to employee, or it causes noticeable diseases on the third schedule, then appoint one or more persons possessing legal or special knowledge to act as assessors or competent persons in such inquiry. So we have the publication of reports. The report submitted to the national board or state advisory board need to be published. Then we talk in terms of central government having powers to direct the state government, for implementation of the provisions of the code. Then there are general restrictions. That was for the restriction for the inspector. No person shall, in respect of the establishment, disclose any information relating to any manufacturing or commercial business or any other working process which may come to his knowledge in the course of his official duties. Then, Section 125 talks about civil courts are barred and they don't have any jurisdiction for any violation or any provisions of this code are made under this code. And it's a general protection. 126 talks about no suit, prosecution, or any other legal proceeding shall lie against any person who has done everything in the good faith or intend to be done in the pursuance of this code. It's the protection given to the person. Then Section 130 talks about every person required to give any notice or furnish any information but to any authority shall be legally bound to do so. So everyone has the compulsion to do so. Then the central government is having the powers to amend the schedules. There are 3 schedules. One is the first schedule is a list of industries involved in hazardous process. Second schedule is list of matters to be decided by the National Occupational Safety and Advisory Board. Then schedule 3 is the notifiable diseases. Then, then now comes the rule-making power. This is the powers of the appropriate government. And I said, please mute your mic, please mute your mics. So the appropriate government may make rules, on the issue given there. If you go to the code, they are given what are the provisions for which you can make a rule. Then we have the central government to make rule. Then powers of the central government to make regulation in relation to mine and dock work. Then it also provides for the prior publication of rules. The prior publication, rules, regulation, bylaw to be made shall not be less than 45 days in the public domain, and then it can be taken up for the further processing. Section 140, this is notwithstanding any law for the time being in force, the central government may make rules to regulate general safety and health of the persons residing in the whole or are part of India, or in the event of declaration of an epidemic, pandemic, or disaster. In case of epidemic or pandemic situation, the government, central government may make rules on safety and health for those areas. Coming to first schedule, it is a similar list of industries involved in hazardous processes. This schedule is under the Factories Act earlier, now it is under the code. So wherever you do these processes, the industries will be declared. And these are all what is existing. I don't want to go to that. But up to 29, the current Factories Act has only up to 29. The first point is now all these processes are called as hazardous process, applicable throughout the establishment, number one. Then it talks about additional sections like printing, dyeing on fabrics and textile, plywood and laminate, manufacturing process. And then we have processes involving usage of radium or radioactive substance, stone crushing, extraction of oil and raw material from scrap, tire, cigarette industry, shipbreaking industry, hazardous waste and e-waste, semiconductor manufacturing, styrene manufacturing, handling and processing, nanoparticles, as well as manufacturing, processing and preparation of utilization of mercury. And you can see very importantly, this schedule, this number 40 is linked to the list of notifiable diseases. It means the industries where there's a possibility of occurrence of a notifiable disease, that industry is declared as a hazardous process under this code. This is the linkage as per the Schedule 1 as well as the Schedule 3. And coming to the second schedule, this is, as I told you earlier, Section 82F. These are the matters which are to be decided by the National Advisory Occupational Safety and Advisory Board. And you can see the sections in the Factories Act, Chapter 4A, are given here. And the board will make standards for these activities. You can see it covers almost all the 13 legislation put together, and it is brought out here. I don't want to go in because it is available in the public domain. You can also download and read them. Then we have third schedule. Again, you have 29 industries. The advantage here is the 29 industries are currently, the 29 notable diseases are currently for the factories, but now this becomes uniform for all the establishments. So therefore, occupational safety and health has been extended to all the categories of industries and workplaces. To sum it up, before I conclude, we have third-party ID and certification system, and we have adequate safety in case of women in dangerous operation, a single unified registration, electronic maintenance of records, furnishing with serving of notices, compounding of offences have been given, enhanced penalties are provided under the code. And there was some question, people are talking, and I thought like we also put it. So safety officer, factory 500, hazardous process factories 250, BOCW 250, mines 100, welfare officers 250 workers. Need is a threshold limit or need minimum thing for a welfare officer in a plantation, factory and mine. And threshold for canteen, 100 workers. For a crèche, 50 workers. For to have a crèche, you need not even employ women workers. Earlier, the crèche provision was there for 30 and above women, for employing 30 or more women employees. Now, by employing 50 workers, then you need to maintain a crèche. Then we have license for contract labor, 50 workers. And for BD and cigar manufacturing, even one worker is there, that should be licensed. And coming to the threshold part of registration, as I told you, section 310, annual health checkup as prescribed, and of course, all other things are given under these regulations. And we come to the final slide of my presentation. I think at this point I'll stop and open for the question and answer. I will go one by one. I think they have some chat box, something I've already explained. But I'll come to the place where now it's coming. Yeah. Safety of the appointment on ordinary 500 workers. But if any company having 10,000, there is no clear. Basically, that's what I told you. The code provides for the minimum number of safety officers. The number is more, what is the slab, everything will be provided in the rule portion by the appropriate government. That is already taken care by the appropriate governments. Then the competent person and experienced person. Basically, the experienced person is a generic term. It is not a legal term. It is not referred to the law. But whereas the competent person is defined. A competent person is a person who is having the necessary knowledge, having facilities at his disposal, and who can do certain test and examination as per the law. And the chief inspector of factory is the authority to approve the competent person. Can a safety officer be prosecuted? You please see the entire penalty provision. It only says a person or any person. So it means it will include safety officer is also a person, number one. Number two, in case, if you see in a real scenario, if an offense is committed, as per the IPC, anyone who has committed such negligence, culpable homicide not amounting to murder, they can be prosecuted. So any person includes safety officer also. And a new order issued for, there is no new order as such for the safety and welfare and health policy. And factory notes slides shall be, I think it's a public domain, it's PDF, you can go through it. And We'll also like to, and the OSH rules have been rolled out. See, so basically almost all the states have done their work, and they have also gone with their states are going with the public, putting in the public domain. So that particular front things are progressing very well. Then this I have already explained. Safety order. And advisory board. In fact, it's a very interesting thing. The advisory board. Basically, what happens currently, the DG faculty is doing the role of framing rules. We frame model rules, and we take every annually one CF conference, take the agenda points, take their views, and based on their views and agenda point, we form working groups and we make standard, we make rules, and then we get it approved by the government. Then we circulate to the state CAF and they make statements. This is the process adopted. So the advisory board, it's a tripartite. The labor secretary, the secretary labor and employment, government of India is the chairman of the board, and it has different members, PB Party, BGMS, BJP, and so on. Representatives of the trade unions, employer association, subject experts, and principal secretaries of the state government. Basically, this board we can make so many committees to support the board. Because board is a tripartite authority. They can form multiple technical committees, assign number. Suppose if you want to make a standard, see, the board can set the standards and give it to the central government, advise the central government. Central government take a call on it. The advantage is the standard framing process has been further simplified, and of course, the system is made such that the process will immediately happen, and it can also be very vibrant and dynamic when it comes to updating the standards. That's the whole objective. They are there to advise on standard, rules, regulation, and also how this legislation is being enforced. All those things are coming there. WhatsApp group, I think I leave it to you people. You can do it. See, there can't be I do not know. This question is very difficult to answer. Transition period with the government policy decision. But however, the code can be implemented by giving a specific date. From that date onwards, the code will become enforceable, and that date onwards, the existing current 13 legislation are set to be subsumed, of course, according to the rules and regulations made there and then. Third-party audit, we have said, section 37, and certification part also, it all talks about the scheme. You would have seen when I explained that session, I said that it's a kind of a scheme, and that scheme decides on everything. And 18, it's basically safety net standard, and the section 18 is related to schedule 2, which talks about 18 to have list of matters. Basically, it talks about all the hazards, safety net standards, medical examination, biological hazard, physical hazard, and so on. And the list of matters are connected to section 18 to F. So these standards, once framed by the government, declared by the government, it will be enforceable throughout the country. It's like, one nation, one standard on safety net. This question still the policy decision of the government. And see, basically, this particular point is very clearly said as of now, if the construction activity is going inside a registered factory, the provisions of the Factories Act alone are applicable, because to avoid application of dual legislative inspection system. Whereas at the Greenfield project, then it is called as, then DOSWR will apply. The OSH code is basically, this code is on occupational safety and working conditions. It is not OSH code, OSH WC code, because the code is specifically focusing on occupational safety and working conditions. Therefore, the OSH WC code has come. And we have same way, the AFH doctors, occupational health center requirements, and your medical examination procedures, everything will be provided in the standard. Of course, periodically, everything will be given in the state rules. There is no change in the pressure vessel. Pressure vessel is again, it will come under competent person only. Now, throughout India, the competent person only can do the pressure certification for external and then internal and hydrostatic and your IDP technique, ultrasonic, everything will come here. Medical officer, yes, now we come to a very important question. For appointing Section 42 medical officer, AFL is not a requirement because this is the doctor appointed by the government. Because the certifying surgeon, current name, Section 10 of the factory, they talk about certifying surgeon. So, whereas the AFH will become a qualification for the factory medical officer to be appointed by the employer or for the construction medical officers. I think the standard is the policy decision. See, this is now, if you see the education qualification, experience, everything now, because, basically it is the appropriate government decision. So, uniformity, we are taking sufficient measures to see that the uniformity is taken care. Then we are working about single medical officer for factory and mine will come on. No, that can't be a single medical officer. Of course, you are also having factory medical officer on part-time basis. See, double employment is only for the workers. It is not for the managerial cadre. And of course, it's a national program, so we have to go with the corresponding language. We are trying to do it. And of course, that's it. Any other question? I could answer all your questions, I believe. If any other question, you can raise and talk also. We have another 10 minutes. And of course, ADAs, PDA courses are mandatory for appointment of safety officer. That will be provided in the rules, which are going to be published by the appropriate governments. There is another question, last question. Yes, fine. As I told you, this is section 37 of the code, talks about third-party audit and certification, which also talks about the government should evolve the scheme, and the scheme will deliberate on these things. The point here is it's a very important question Dr. Vijay Anand has asked. Of course, the law does not talk about doctors to be on the roll. The doctors to be provided. Putting them on the company role or the contract role is altogether a different subject. The law only talks about having a factory medical officer, that's all. The right of workers, key impact will be all the workers, right of workers, what is existing and what is anticipated, because it's a modern legislation. Enough provisions are given for the right of workers. And I think there is a new question. This question I have already answered. That factory construction activity and logistic factory will come under factory. If it is a greenfield project, it will be coming under VOSWF as of now. It's only to avoid double jeopardy, or I would say application of two laws for a single premises. Any other question?
Sir, we will take two more questions, sir. Last two more questions.
Yeah, it goes into this lab. As I told you, safety officer lab is given in the state rules and the appropriate government rules. And somebody has got a very question, it's like thermal power plants. See, safety officer is not the question of creation of cadre. Safety officer is the appointment of safety officer, possessing the qualification and experience as prescribed under the state rules or the appropriate government rules. No. Basically, you shouldn't worry about all these things. The Factories Act is the current legislation in terms of a factory. And once the government gets a call, then the new law will come into force. And of course, the permissible exposure limits, also another question. The competent person will be licensed by the chief inspector company. You see, the whole code now, the BOCW, everything will go. They all come under the broader definition of establishment. So it will be applicable for all the sectors from the concerned inspector of factory. The permissible exposure limits are given as a standard. And of course, the Act also provides for providing that. Their supervisor is 18,000 currently, or any other amount as will be prescribed by the government. I think, shall we close at that point? Because you said 2, I have already taken 3 or 4 questions. I now leave it to the organizers.
So thank you, sir.
Thank you very much for all of you for your participation. I could find out the questions which clearly say that you listened a lot and you really followed the session. And I'm also, I feel that I should appreciate all of you for the dedication which you developed and the keen interest which every one of you has developed in understanding the code and the new provisions which are going to come. And basically, I always tell a safety professional is the one who knows about the law, who knows about the current development, technological advancement, and only can be successful. I thank the organizers for the platform as well as the delegates for their active and very interesting participation. Nice questions. I really enjoyed all the questions. Thank you. I leave it to the organizers for.
Sir, thank you, sir. It's a mind-blowing session as usually. Thank you. Thank you for sparing your time on Sunday. And also, we thank the participants for rendering your time on Sunday. For a formal vote of thanks, we welcome Mr. R. Srinivasan. Srinivasan, sir.
Mr. Satya, good afternoon. I am audible, Satya?
Yes, sir, you are audible. You can continue.
Yes, sir. Good afternoon to all the participants and good afternoon to all this vote of thanks on this 50th Empowerment webinar session. On behalf of Team Infinity, we show our gratitude to Dr. R.K. Elangovan, sir, Director General, DG Fasley, for spending his valuable time and delivered a highly effective lecture on
I think there is a network issues from Srinivasan sir. Okay, thank you, sir. Thank you, Dr. Elangovan, sir, for a very effective session. And also, we have been thanks all the participants who have been rendered the support throughout this 50th session, 50th week. It is possible only because of you. And we like to thank our Infinity advisors, our Dr. Elangovan, sir, our Yoga Principal of Mayor, and also Sports Director, retired from Tamil Nadu, and also Dr. Vipinendran, sir, from Anna University, and also Jagannathan, sir, from RLI, and Madengi, madam, from Ramachandra Institute, and so many of us have been a pillar for this event to making this as a grand success as a 50th event. Last but not least, we like to thank the Almighty for giving this time to ensure that the program has been done in a very successful manner. And I once again thank you all. And once again, thank you, Sir R.K. Elangovan, sir. And thank you all for making this day a very memorable day. And many of the students have been participated. They have been inspired from you to take this profession, safety as a profession, to ensure that they save many lives in the future. And we join hands to ensure that our society has been created a safety society and we can able to give it back to our next generation. Thank you once again, sir. Jai Hind. We have been posted.
Thank you. Thank you.
Thank you, sir. We have been posted the feedback link in the chat box. You can able to the participants. You can able to use this, and you can able to fill your feedback form. Thank you. Thank you once again. Have a safe Sunday.